A ruling by Supreme Court Judge Ian Winder expected to impact government's plan to stop the practice of double dipping in the public service. Double dipping means that an employee would apply for a sickness benefit from the National Insurance Board for loss of wages while continuing to receive those wages from the employer. In a ruling handed down Friday in the case involving the Bahamas Educators Managerial Union, Justice Winder noted that any attempt by the government to change that policy without the written agreement of the union would be a violation of the law. Director of Labor Robert Farquharson says the ruling has implications for other members of the public service moving forward.
As to the world of work, is that any employer, regardless of who it is, even if it's the government of the Bahamas, cannot circumvent the provisions of Section 51 of the Industrial Relations Act. Once a collective bargaining agreement is signed and is registered, it is legally binding and it's enforceable. And that's the general principle that has always applied. It's a testament to the Supreme Court, and Justice Winder ruled on the side of the union. Notwithstanding the fact, in his comments, he spoke about how difficult it would be for persons to enjoy both the benefits. But he says he has to follow the law.
Farquharson also noted that the Public Services Union and the Water and Sewage Union also have cases pending on the double dipping issue.
What this case does, it establishes a legal principle, and the legal principle may apply in the matter with the Bahamas Public Service Union, and it may or may not apply in the matter with the Water and Sewage Corporation. But a decision has to be taken by the employer, in this case, who is the government, exactly what they want to do. I'm sure they are taking advice from the Office of the Attorney General, as that's the way forward. I'm not certain if the Justice Winder decision will be appealed, but the decision is clear. The decision has said that no employer, including the government of the Bahamas, has the legal authority to unilaterally change the terms and conditions of employment outlined in the collective bargaining agreement. Don't care what the decision taken as policy.